All right. Well, thank you for everyone who's watching this section about probate, conservatorships, and estate planning. We are excited to be here and give everyone an overview. For Before we begin, there's a disclaimer. This is just a kind of a presentation webinar. It's not a legal clinic. So if you have any specific questions related to your matter, we will share our contact information and you can reach out to us one-to-one. Nothing in this presentation is to constitute legal advice. So presenting today, Mika.
Hello, everyone. We're excited to have you. My name is Mika Domingo. I am founder and managing attorney of MS Domingo Law Group.
Hi, everyone. My name is Alyssa Daatio. I am an associate attorney at Candelaria PC.
Hello, I am Nicole Ramos Takemoto, and I am also a trust and estates attorney at Candelaria PC. So today we will have 4 different sections: 1 estate planning, then probates, then conservatorships, and then Q&A. We only have 10 minutes per topic or so, so it's going to move a little bit fast, which is why it would be good for you to reach out to us separately after if you have any questions. So to begin with estate planning, what is estate planning? Estate planning is the preparation of documents that cover managing someone's financial and other affairs in the event of their incapacity or death. A lot of people wrongfully think that it's only for, post-death planning, but actually a lot of the documents that you prepare when you do an estate plan takes care of during your life. If you become incapacitated, who can manage things for you? So who needs an estate plan? I wonder if this, anywho, who needs an estate plan? Pretty much everyone. Because regardless of what property you have or don't have, you still might become incapacitated during your lifetime or need, a medical directive. So a lot of people think that, estate planning is only for the wealthy. I don't need a trust because I don't own property or I don't have anything. And that's probably not true. It's important to talk with an attorney and tell them about what you do have, because it is very likely that you should have at least a very basic estate plan. But the triggers for understanding if you absolutely need one is if you own real property. That's a surefire way that you will end up in probate because of the value of that property. If you have minor children, that's another thing that would lead you to need an estate plan, because you would have to nominate guardians for minors and then decide who would take care of their assets or inheritance until they reach adulthood. So owning property, having minor children are the big ones. So what makes up an estate? It's all kinds of property, not just houses and bank accounts and cash, but it also includes things like annuities and bonds, life insurance policies, retirement plans, and business interests. And there are even things like copyrights that can also be controlled by an estate plan. So it's any kind of property that you might have, tangible or intangible. Why do I need an estate plan? Well, one of the reasons you would need an estate plan is if you are incapacitated. So let's say you are, let's say that you develop an illness and then you're unconscious. During the time that you are incapacitated, you will have a durable power of attorney, hopefully, and this will allow an agent to make financial and legal decisions on your behalf. You should also have an advanced healthcare directive to designate someone to make medical decisions when you can't do those for yourself. And then a living trust that is funded with assets. If you are incapacitated, whoever is the successor trustee can take over and make sure your bills are paid and all of those things. So you need an estate plan in case you become incapacitated. And then you also need an estate plan so that there is an orderly distribution of your assets after your death. In this way, you can tell people, you can say specifically who your beneficiaries are. A lot of people pass away without a trust or a will, and in those cases, the California Probate Code says who inherits your estate. And sometimes this doesn't line up with what you would want to do. So it's important to have an estate plan so that way your wishes are definitely documented and someone can follow them. So the documents in the estate plan, I briefly touched on this. It's a series of documents. You need a revocable living trust, a pour-over will, durable power of attorney for finances, and then advanced healthcare directive. So a living trust, you'll hear a lot of people use the term living trust. That means it's something that you set up during your lifetime. While you're alive, you work with an attorney to draft the terms and then you sign it and fund it with assets. So it's called a living trust because it's set up during your lifetime. If it's a revocable living trust, then the person who sets it up, they can amend or revoke the trust at any time during their life. So if they want to make a charitable gift or they want to disinherit a family member, if something changes, you can amend your living trust. After the settlor's death, so the settlor is the person who's creating the trust, after that person dies, the trust is irrevocable and can't be amended. So that's how you know that your wishes will be followed. No one after your death can say, change the beneficiaries or alter the proportions or anything like that. A pour-over will, even though you have a trust and that is the cornerstone of your estate plan, a pour-over will is still important. And it's called a pour-over will because it simply says, I leave everything to the trustee of my living trust to be added to the trust estate. So ideally, you would set up a living trust, you would retitle your assets to it, such as retitling your home, retitling your brokerage accounts or your business interests. But just in case there's an asset that you inadvertently leave outside of your trust, the pour-over will captures it and makes sure it ends up in the trust. So this possibly, depending on what the asset is and how valuable it is, it still might need to go through a probate, but ultimately the beneficiary of this pour-over will is the trust, the trustee of the trust to be added to it. So the will is one of the backup plans for trust funding. Durable power of attorney for finances. So this is a document that's created during your lifetime and it's effective. There's different types. So there's durable and non-durable. Durable power of attorney means you're setting it up now, and even if you become incapacitated at a later time, it's still effective. It does not become ineffective because you became incapacitated. So that's why it's called a durable power of attorney. Immediate or springing, you can have a power of attorney that's operative as soon as you sign it. So as soon as you execute the power of attorney, it is operative and you can use it to manage someone's affairs, versus springing, which means you sign the document, but it's not operative until the person who signs it, the principal, is deemed incapacitated. And the document itself will say the methods that a person can be deemed incapacitated. It might be by certification of one physician or two physicians or with a court order. So a springing one, it's not effective until there's a determination of incapacity. And then limited versus general is pretty easy. General is very generic, where it's like every type of transaction is included. You can act on behalf of the agent in any way that they could act for themselves. A limited power of attorney is more related to one transaction or one power. So say, for example, selling a house, you can have a limited power of attorney that names someone to act on your behalf only related to this one transaction. It's not the overall blanket designation of a general power of attorney. And then advanced healthcare directive is similar to a power of attorney, but it's Instead, it's for medical decisions. So if you are not able to make your own medical decisions, you're naming an agent to make those decisions on your behalf. So this is not related to finances or legal documents. It's only healthcare decisions. And I think that's it for estate planning. I believe Mika will go over probate.
Thank you, Nicole. Can you see my screen? Thank you. This portion of our presentation is on probate. What is probate? Probate is a legal process that occurs when a person dies and their property needs to be distributed. Probate can occur when a person dies without a will, or a person dies without an estate plan in place. The heirs or beneficiaries of an estate need to be determined. The worth of a decedent's property needs to be determined, and the decedent left some liabilities that need to be taken care of, and the property of the decedent need to be transferred to the heirs or beneficiaries. Now, there are quite a few terms that I just mentioned that I'd like to define. Decedent is the term used in the process to refer to the person who has died. And the administrator is the person who is designated as the representative of an estate if there is no will. And the executor is the person who's designated in the will. That's the agent. So the personal representative is a term used to refer to the executor when there's a will and the administrator when there is no will. An heir is a person who is determined to have the right to inheriting something when someone dies without a will, and we call that person to have died intestate. And a beneficiary is a person who is specifically designated by a will to inherit something when someone dies. Did you know that according to a survey study of 1,500 American adults conducted by caring.com, that an estimated 68% of all Americans die without a valid will? And we expect this to continue to increase as our population grows. But our goal is really to provide education so that it becomes sort of second nature, right? To, anyone who's over 18 should create a will. As you can see in this slide, a lot of people don't understand what happens to the assets and what happens when one dies without an estate plan. Nicole had mentioned, people with children that would need to be a designation, for guardians in the event that the parents die. And so most people don't want to think about that, right? The worst case scenario, but it's important to have those testamentary instruments in place. In this next slide, you can see, based on caring.com's research, there's a question as to what would happen, what people think would happen to the assets and children if they were to pass away without an estate plan. And you can see it's 37.1% here. The courts will decide who gets my assets. That's the result of the survey, and 29.3% of respondents don't know what happens. So how do you even begin to start a discussion about probate? In this next slide, you will see some very useful questions. So the first one is, obviously, if there is information about someone losing a loved one of the questions that would be helpful is to ask whether or not that person, your loved one, had a will. And if the answer is yes, you don't stop there. because a will is, while it's effective upon death, it doesn't really answer all the questions one might have about an administration of an estate, right? So as you can see from the flow chart, if the answer is no, it's possible that the decedent, the loved one, did have a trust, right? And if the person did have a trust, then you would ask the question of, well, did the decedent's assets get funded into the trust, right? So if the answer to did your loved one have a will is no, and did your loved one have a trust is no, then the next question would be, did your loved one have any assets on the date of death and only under their name, right? Because if the answer is yes, then the question is, well, what about those assets? If the assets were only held under the decedent's name, what if the assets were below the threshold? So in probate, if the estimated value of those assets exceed 187,500, and then you would look at needing to file a petition for probate. Now, going back up here in the flow chart, if the decedent had a will and the answer is yes, you also don't stop there, because as I mentioned, you have to look at what the decedent left behind. Let's say that the decedent did have a trust, right? That there was a trust, there was a will. Do you need probate? Well, we don't know, because we have to investigate further. Did the decedent have assets funded into a trust? Good. But did the decedent also have assets that didn't make it into a trust? If that's the case, then you could potentially still need to do a probate. So the process requires some investigating. One of the things we always ask in an intake is, what on the date of death, what did your decedent leave behind? If the decedent left behind assets that were held in joint tenancy with right of survivorship, then the surviving tenant, of course, receives the interest in, let's say, a bank account, right, or even a home. But let's say the property was held in a tenancy in common, and so the surviving spouse does not take the decedent's share, they would still need to be a probate. How do you initiate a probate? Well, the probate process begins when the agent, it could be the executor of the will, files that petition in court. If there is no will, there would still be a petition in court, petition for letters of administration. The petition gets set for a hearing, and the agent, the executor, or a proposed administrator is required to provide notice to all individuals entitled to notice. Now, the hearing is scheduled usually several months, depending on the county and depending on where you are. And once the hearing takes place and there are no issues, then your agent gets appointed. The executor gets appointed as executor, administrator gets appointed as administrator. And the next step for that agent would be to marshal the assets. It's always a good idea to know what the assets are going into probate before you file. But oftentimes what happens with fact gathering is that after we file a probate, and you're doing some investigating, you realize that there might be other assets that you didn't include in your petition for probate when you're totaling the assets. On page 2 of the 4-page petition for probate document, it asks you to identify the real property and estimated value, and personal property and estimated value, less encumbrances. It's expected that that could change. Here in the slide, it says finalizing the probate matter. It's really not as, we only have so much time. So it's really not as easy as after, you marshal the assets, maybe after you marshal the assets, you have to sell some of the property, and proceeds of the sale will go into an estate account, or maybe the heirs would like to receive interest in the property. There are other steps in between before you finalize the probate, of course. we just wanted to give you a summary, a kind of an idea as to what happens in a probate. So oftentimes potential clients ask, well, is there an alternative to probate? Here, but I have a slide on spousal property petition. Now, this is an alternative to probate when you have a situation where the decedent didn't have the property in a trust, and the surviving spouse wants to avoid having to file that probate. And this form that it can be used is useful because you can ask the court to confirm that the property was community property. And it should be transferred to the surviving spouse. This is a very simple form that can be filed by either the surviving spouse or the representative of the surviving spouse estate, and will help avoid a probate. In the absence of any confirmation that the property was community property, then the estate will likely go through a full probate proceeding. Another alternative to probate, it may apply to some cases, is what we oftentimes call the small estate affidavit, as a simple form. Sometimes the decedent may not have, may have some assets, but that were left under their name, but the assets do not exceed the threshold. And so the small estate affidavit under Probate Code 13100 can be used to show that the assets do not exceed the threshold, and the assets should be distributed to the rightful heirs, and that there is no probate pending in the court. So that would be a general overview of the probate, and I will now have Alyssa go over conservatorship.
Yes, and then I will share the screen for conservatorships. Okay, there we go. Alyssa, just let me know when to advance.
I will. Thank you very much. So I'm going to present about conservatorships. So what is a conservatorship? A conservatorship is a protective court proceeding where a judge appoints an individual to act on behalf of an individual, an incapacitated individual, because that person needs help. And so the standard for establishing a conservatorship is actually quite high. And that's because a person's civil rights are going to be taken away. And so just some general terms that you might hear me use during this presentation. So the conservator is the person who is appointed to act on behalf of that individual, and the conservatee is the individual who lacks capacity. Next slide, please.
I can figure out. Okay.
So we said capacity a lot during these presentations, and what does that actually mean? So as a baseline, every single person is presumed to have capacity. So when you're petitioning for a conservatorship, the person bringing the action has to actually present substantial evidence that the proposed conservatee has a deficit in their mental function, and that deficit has a connection or a correlation between the conservatee's actions. And common examples of that can include maybe the proposed conservatee is unable to communicate, or maybe the proposed conservatee is unable to understand the consequences of their decisions. But the threshold has to be that this is absolutely necessary to protect them. And in order to prove capacity, as part of the conservatorship petition, the petitioner has to provide a letter from the doctor, also known as a capacity declaration, demonstrating that that individual no longer has capacity to do certain things. There are many types of conservatorships. So there is a conservatorship of the person, a conservatorship of the estate, limited conservatorships, temporary conservatorships, and LPS conservatorships. So a conservatorship of a person is a situation where the incapacitated individual is unable to provide for himself or herself in their physical health, food, shelter, and clothing. So that basically means they can't manage their day-to-day lives, and they will need someone to make those decisions for them and help them with that. That can also include, administering medication for them as well. There's also something called a conservator of the estate. And the threshold for that is that the incapacitated individual has to be substantially unable to manage their own finances or substantially unable to resist fraud or undue influence. So the main duties of a conservator of the estate would be to pay for certain bills for the conservatee, invest their assets to make sure that money is growing, and essentially to prevent scammers from taking those funds away from the conservatee. There are also temporary conservatorships, and a temporary conservatorship can be of the person, of the estate, or both. And temporary conservatorships only arise when there is an immediate need for someone to manage assets or to take care of a conservatee. And that threshold is, even more strict than a general conservatorship because it happens right away. Oftentimes a temporary conservator will be appointed while we are waiting for a general conservator to be appointed at a later date. There are also limited conservatorships. So a limited conservatorship is for an adult who has a developmental disability. And a developmental disability is often, documented by the different regional centers in each county. And limited conservatorships are different from temporary conservatorships, general conservatorships of the person in the estate, because this does not, result in the proposed conservatee losing all of their rights. So their rights, the conservator who is appointed in a limited conservatorship will only have the ability to have certain powers that are listed on the screen. And then the last type of conservatorship is called an LPS conservatorship. That comes from the Lanterman-Petrus Short Act. And this is governed under the Welfare and Institutions Code. So this is oftentimes someone who has a mental illness or a substance abuse disorder. And these types of conservatorships only last for a year. Every single year, if the person is under an LPS conservatorship, they will be reevaluated by the court. So as I said before, the standards are very, very high in order to establish a conservatorship, mainly because this will last for the conservatee's entire lifetime. So the person bringing the petition has to demonstrate by clear and convincing evidence that that person lacks capacity, and they need to demonstrate to the court that there are no least restrictive alternatives available that can act in place of a conservatorship. So we actually talked about some of the different alternatives to a conservatorship. So estate planning documents are very important. They avoid probate, as we've talked about, but they can also have the effect of avoiding a conservatorship, because these documents can name someone to act on your behalf when you're incapacitated. And the court will want to know that. The court will want to know if the proposed conservatee has ever executed an estate plan, because the court is very cautious in just granting these conservatorships. And a new type of alternative to a conservatorship is called supportive decision-making. So this is new. California just enacted this. And essentially a supported decision-making agreement is when an adult with a disability chooses to make an agreement to name a supporter. And that supporter will essentially help that disabled adult implement and be their voice and communicate to different third parties on their behalf. And lots of different institutions, healthcare agencies are starting to accept these types of agreements because we've seen a shift away from, starting conservatorship proceedings. So what happens if someone is filing a conservatorship petition against me? How does the court protect you? What are your specific rights? So again, California has revised the laws regarding conservatorships to protect the proposed conservatee. One of the new things that they've done is to require court-appointed counsel for every single person who is subject to a conservatorship. And that counsel will be required to zealously advocate on behalf of a proposed conservatee. So that means if, the proposed conservatee is objecting, that attorney will be that person's voice and listen to their wishes. Another way that a person is protected in a conservatorship proceeding is through a court investigator. So each county will assign a court investigator anytime a conservatorship petition is initiated. That court investigator is very skilled. They're required to conduct interviews with the proposed conservatee, with family members, with the petitioner, and their determination is whether or not this conservatorship is in the best interest of the conservatee.